Issue has stirred controversy throughout the United States, and today we have two guests on opposing sides of the amendment, Phyllis Schlafly and Wilma Heide. Now, to illustrate how controversial the issue is, we tossed a coin to see who would speak first. Speaking out against ratification of the Equal Rights Amendment is author, wife, mother of 6 children, and the national chairman of the Stop ERA Committee, Phyllis Schlafly. Welcome.
Thank you.
Nice having you
Delighted to be here.
Mrs. Schlafly, why are you against the Equal Rights Amendment? And may I say that we are going to allow you, as we will Ms. Heide, 7 minutes, and then when you hear the sound of the piano, you'll have about a minute to wrap it up, okay?
Fine. Well, when I first heard about the Equal Rights Amendment, I thought it might be a good thing. I thought it might improve the status of women and give us equal pay for equal work. But the more I looked into it, I found that women already have equal pay for equal work, now guaranteed by the Civil Rights Act of 1964, but particularly by the Equal Employment Opportunity Act of 1972. And that act is very specific in regard to hiring and pay and promotions. If any woman thinks she's been discriminated against, she could file her claim with the government and they'll pay the costs. A few weeks ago, this commission forced AT&T to make a $38 million settlement to its girl employees, and I think that shows what can be done by the legislation already on the books. On the other hand, when we looked into this amendment, we found that it will have many unfortunate consequences that we didn't realize in the beginning. For example, the laws of every one of our 50 states require the husband to support his wife and family. And you know, a lot of wives don't realize this, and for those who don't, I suggest that they ask their lawyer to get them one of the most comprehensive reference works on American law, which is called American Jurisprudence Second, Volume 41. And it spells out all these wonderful rights that the wife has to be supported by her husband and to be provided with a home by her husband, things that are very precious to women. Well, now the Equal Rights Amendment will come along and invalidate all these state laws, because no longer can you have any law which imposes an obligation on one sex that it doesn't on the other. And you don't have to take my word for it. The proponents of the Equal Rights Amendment use as their piece of scholarship this long article in the Yale Law Journal. And in here it tells very clearly that after ERA is ratified, the courts will have to strike down non-support laws which impose the duty of support on men only. So this is what they want, and this will take away from the wife her legal right to be a full-time wife and mother supported by her husband. Now, the second large area is the matter of the draft. The Equal Rights Amendment will positively make women subject to the draft on the same basis as men, and I don't understand why women should be agitating for this. The proponents say Congress already has the power to draft women. Well, that's right, but Congress has used the power to exempt women, and that's the way we like it. And the point is that if ERA is ratified, Congress will no longer have that option. Congress will have to be compelled to draft women on the same basis as men. Now we're told that we're not going to have any more draft. We're going to have a volunteer army. I hope that's true. But you know, they've just conducted the lottery just to make sure that men are available for registration. And we know that for the last 33 years we've had a draft, and we've had 3 wars. And I hope we've arrived at some point that we're not going to have any more wars or any more draft. But I think it's rather foolish to think that that is the case. And if we're confronted with a national emergency, this means that women will have to be drafted on the same basis as men, and that means all throughout. That means in combat, carrying the same 40 to 50 pound packs, put on warships, and whatever. And it's spelled out in page after page in this article, which is used by the proponents as what they want. And so I think this is very hurtful to the majority of American women. They third area is the matter of the protective labor legislation. The Equal Rights Amendment will wipe out all the protective labor legislation on the books. This is an area which is important to the woman who does manual labor, who works in industrial work. And this is why the AFL-CIO has been consistently against the Equal Rights Amendment. I used to do manual work. I was a gunner on the night shift at an ammunition plant. That's the way I worked my way through college. And I could fire the guns just like the men. But when they had to change that 100-pound armor plate that we put the bullets through, I didn't have to change it. And there are all kinds of jobs in industry that women don't want to do and shouldn't be made to do. I feel that in your intellectual and professional fields, a woman can compete equally with a man because she's just as smart. But in physical labor, a woman can't compete equally with a man, and it's unfair to her to make her try. Another area is the matter of Social Security. Now, at the present time, a woman who retires gets a larger financial payment than a man with the same number of years and salary. This is a preference that women have, and that's the sort of thing that would be wiped out by ERA because you can't have any difference between the sexes. During most of the time that the Equal Rights Amendment was considered by the Congress, it had attached to it something that was called the Heide modification. This said, nothing in this amendment shall be construed to deprive women of any of the rights, benefits, or exemptions they now possess. Now that was good because what do we mean? The right of a wife to be supported by her husband, the benefits that women have under Social Security and protective labor legislation, and the exemption that a draft-age girl has from the military. But that amendment was taken out just before it was passed by Congress. And that means that the legislative history shows that women will be deprived of these things if ERA is ratified. So these are some of the reasons why the Equal Rights Amendment is being rejected by so many states this year. And this is the majority report of the House Committee of Congress that took the testimony and heard the hearings. This majority report said, in talking about ERA, not only would women, including mothers, be subject to the draft, but the military would be compelled to place them in combat units alongside of men. It could relieve the fathers of the primary responsibility for the support of even infant children, as well as the support of the mothers of such children, and cast doubt on the validity of the millions of support decrees presently in existence. So these are some of the reasons why we hope that ERA will not be ratified, and we're very pleased that 12 states have rejected it this year, and we feel it will not go into the Constitution.
Okay, you'll hear the other side after these messages. We'll be right back. Schlafly is against the Equal Rights Amendment, and now speaking for the ratification of the Equal Rights Amendment is a homemaker, parent, registered nurse, and the president of the National Organization for Women, Ms. Wilma Scott Heide. All right, Ms. Heide, why are you for the Equal Rights Amendment? Now, you have 7 minutes, at which time you'll hear some soft piano music, and you have about a minute or so to wrap it up, okay?
Well, first of all, let's state what the amendment says. The Equal Rights Amendment to the Constitution, already passed overwhelmingly by the Congress, says equality of rights under the law shall not be denied or abridged by the United States or any of the states on account of sex. So this amendment speaks only to the laws, both federally and in the states. What it means is that sex is not a valid criterion on which to deny the rights of any of our citizens. I think also your viewers and listeners should know that when the Constitution was written by our forefathers, no foremothers, that at that time, Negro males were considered legally 3/5, that is only a fraction, 3/5 legally of a person. No woman of any race was considered any fraction of a person. Now that has not changed today. So this means that as a matter of fact, that women are not included in the intent and in the content of the Constitution, which is a basic legal document of the land. Now, there are many reasons why we're for this, and I think people should know that not only did the Congress pass it overwhelmingly, all of the last 4 presidents, including the incumbent, have been for it. All of the political parties except the American Independent, which is essentially the extreme right wing, and the Communist Party are opposed to it, but the other political parties have been for it. Now, it speaks only to the laws. It does not speak to private practices or customs. There are women, since we are not included in the Constitution, and no Supreme Court has ever declared unequivocally that women are to be considered persons under the law. This means that women can be and have been denied due process of law and equal protection of the laws. Now, they are denied in terms of educational opportunity in public institutions and educational institutions that receive public funds. We are denied opportunities to open a business without going through court or receiving approval of husbands. We are denied credit. We are denied the right to have a separate domicile in at least 5 states in this country. Some women don't own the clothes on their back without their husband's permission. Women have to go through a particular kind of procedure in order to be eligible for jury duty, which is a right and a responsibility and an opportunity of citizens. There are some 800 laws in this country, by law, that actively discriminate against women. Now, Mrs. Schlafly mentioned that the Title VII of the '64 Civil Rights Act already takes care of this, and the Equal Employment Opportunity Act of 1972 will take care of it. Now, that act speaks only to private employment. It will not take care of the fact that, for instance, under government employment, whether it's on the federal, state, or local level, and this includes teachers and others who are employed by public bodies, can and are discriminated against in employment and practices and indeed in programs. So what we are talking about is that under the law, women and men, girls and boys, must be considered equally, that consistent with practices of democracy, that we must all be treated as individuals. Now, it's also been mentioned the opposition to the Equal Rights Amendment is on the basis of being drafted. Well, Congress, as has been mentioned, already has the power. The draft is a moot point. And as a matter of fact, never more than 5% of males have been drafted. Never more than 1% have been in combat units, and less than that actually in the front lines. What will happen with the volunteer army is, as it stands now, women must have higher standards in order to be eligible for the military. And also, women are denied the opportunities that do accrue from being in the military, the GI benefits and education, employment, and housing, and counseling, medical care, and so forth. As a matter of fact, according to law now, there cannot be more than 2% of women in the military. So this would give opportunities to girls and women that have been available for boys and men and have not been available for them. On the question of the so-called protective legislation in the states, this also has been superseded by the Title VII of the Civil Rights Act of '64 mentioned earlier, and it's really a moot point. But as a matter of fact, the so-called protective legislation, I can assure you, as somebody who's worked as a domestic, as an attendant in a hospital, as a nurse in a hospital, and as in a factory, that what it did was protect me from opportunities. It never protected me. It was always selectively enforced. It never protected me from lifting heavy weights, 100 pounds and more. It never protected me from working 12 hours a day or night. It never protected me from working, say, from 5 in the evening to 2 in the morning. What it protected me from was from opportunities for things that I as an individual could do. The question of whether all women or all men can do or cannot do anything is not what's at issue. The issue is they have a choice. Now, I think we find it really an insult, at best, that anybody would want to deny choices, and that's what it's about, choices, particularly under the law, to anybody. I have enough faith in women that we will exercise the choice with a good deal of judgment. Now, the question of support that's cited, the so-called right to support is more apparent than real. As a matter of fact, it's never called into play unless a woman asks for it, sues on her own, and most women needing support can't afford to, takes an action, or in the instance of divorce. The courts never enter in unless there's an instance of divorce. And as a matter of fact, in instances of divorce, people should know that as it is now, women now pay more than half of the support for children. Women can now be required by law, for instance, to pay alimony in a third of the states. But what will happen is any rights that are now denied, as they are so grievously to women and girls in the states around the country, can no longer be denied. Any benefits.
You have another minute.
Yeah. Any benefits that now accrue to one sex must be available to the other. Again, in each instance, the needs and the resources of the individuals concerned will be concerned. I think that when we look back on this time in our history, we probably will consider it primitive, if not barbaric, that we even considered it debatable in a country that pretends to be a democracy, whether or not the majority of the citizens should be included in the basic legal document of the land.
Okay, both guests will have an opportunity to respond to each other. Following this, we'll be right back. So you have both had your chance for 7 or 8 minutes. I'd like to ask both of you a question, and since Mrs. Schlafly spoke first, I will ask you, Miss Heide, to speak first this time. Now, do you believe that women are discriminated against in society?
Whatever I believe, the documentation of this in the Congress, in conferences all over this country, in literature that's been written and never refuted, is so voluminous. It's a fact of life.
But do you
In other
believe?
words, it's natural.
Do you believe?
I, of course, believe, only because it's true.
Mrs. Schlafly?
No, I don't believe women are discriminated against, and I've been around to the state legislative hearings in 10 states, and in state after state they say, well, the laws are all right in this state, but we want to help those poor women who are discriminated against in other states. And that's what they say in state after state. Now, Ms. Heide pointed out that women are not persons. I suggest that she read the Supreme Court decision in the case of Minor versus Happerstutz, handed down on March 29, 1875, which twice declared that women are persons entitled to all the privileges and protections of the 14th Amendment. The Civil Rights Act and the amendment passed in March 1972 specifically applies to all schools, public or private, whether they are getting a federal aid or not, and to government employees. So I think we now have all the legislative means we can to get equal pay for equal work.
Would you like to add something to that, Ms. Heide?
Well, we lobbied for this bill, so we know something about what's in it. The fact remains, and I would refer anybody to the voluminous hearings that have been held at one time or another, particularly in the last couple of years, on the Equal Rights Amendment as one place that does document the discrimination. Not because I believe it, simply because this documentation has not been refuted.
Okay, Mrs. Schlafly, now how would ratification of this amendment affect you personally?
Well, the most important thing probably is because I have a couple of daughters and I wouldn't want to see them drafted. Now, it's been pointed out that very few get drafted or get into combat. All I've got to say is, thank goodness Congress had the good judgment not to ratify this amendment 10 years ago, or instead of having 50,000 boys killed in Vietnam, 25,000 of them would have been girls, or half of our prisoners of war would have been girls. I don't think this is an invasion of my equal rights that women were not killed and hatched up in Vietnam. So I think that's a very important consideration about the effect of ERA.
Ms. Heide?
I don't know if it'll affect me personally, except psychologically. I want to be part of the basic legal document of the land, and I'm not now. Neither are my daughters. I find it interesting, almost amusing, that Mrs. Schlafly, for instance, is going around the country arguing against the right of choice as it will be provided under the ratified Equal Rights Amendment, when she, as a matter of fact, is herself exercising free choice. I also would wonder if her daughters wouldn't like to have some choices too. I wonder what her children and grandchildren will think about her role in opposition to the Equal Rights Amendment.
Now, Ms. Heide, what happens to the man's role in society if it's ratified?
Well, I think, first of all, men will have more choices and more options than they now have.
I'm going to stay home.
And as a matter of fact, I think in relation to the last question, we think as much of boys and men as we do of girls and women. And the fact that we are willing to have our boys and our men killed and maimed and out killing and maiming, and not our girls and women, I think says something about what we think about boys and men. And I think that...
Mrs. Schlafly?
Well, I think that the Equal Rights Amendment will give husbands who want to get out of their marriage obligations a great opportunity to do so. Ms. Heide said that the marriage contract for support isn't enforceable and the courts don't step in. But 99% of the contracts that are made, the court doesn't step in. If you buy an automobile on time and you make your monthly payments, the court doesn't interfere. If you rent an apartment or lease it, as long as you pay your rent every month, the court doesn't interfere. Now, most people fulfill their contracts because it's the honest thing to do, but there are quite a few of them who only pay up because they don't want their car to be repossessed. Now, marriage is a contract, and if we pass the Equal Rights Amendment, we are proclaiming to all the world that this contract no longer includes the obligation of the husband to support his family. And I think that's a very radical departure from the laws of every one of our 50 states, and so exceedingly hurtful to the rights of the wife and the rights of all American women.
Well, I think it should be known. The truth is, and I'd like to, we stick to the truth here. The truth is that no law that requires that the earning spouse supports the dependent spouse will be nullified. The decision will be made not on the basis of sex, but will be made on the basis of the resources and the needs of the people concerned.
If the wife is working and the man is not working, would that mean the woman would have to support the man?
Women are now sometimes required to support. But the issue here is the needs and the resources. So anything that speaks to the spouse who is earning, supporting that one who is not earning, and the children, will not be nullified. Now, that's a matter of record. That's a matter of record of the hearings and the legislative history on the Equal Rights Amendment.
Well, just may I say to the women that then you're trading in the wonderful rights that a woman has on our law books today to be supported by your husband in exchange for what Ms. Heide thinks the court is going to hold in the future. And that's a very nebulous thing to place your rights on when you've got the law on your side right now.
Ms. Heide, we have about 5 minutes. You can respond to what each other has said.
Well, 98% of the judges now, by a study not done by now, the organization, already take into consideration the resources and the needs of the individuals involved. Women already, in terms of this wonderful right to stay home and be supported, women are already opting in increasing numbers, and mostly as a matter of necessity for working at paid employment outside the home. And that must be available, and every law must provide that there be equal opportunity. And remember, this speaks to the federal and state laws, not the private employment.
Well, that just proves that we've got the freedom of choice right now. And this is what a woman has today, the freedom of choice to be a full-time wife and mother, supported by her husband, or to go into the workforce on the basis of equal pay for equal work, or to do both. We have this choice now. But once ERA is passed, we'll only have the choice to share equally in the financial burden of the family.
We do not have the choice as long as by law and regulations of this land, and this does exist, we can be denied the opportunity to enter into contract without our husband's permission or without going to court. Women now have to do this. Men don't have to. We do not have freedom of choice as long as we are denied credit. And again, this has been voluminously documented. We do not have the freedom of choice as long as we do not have the right to establish separate domicile, and men do.
How are you going to keep a family
together? Wait a minute. I didn't interrupt you. Wait a minute. This is a matter of fact. And remember, I could cite about 800 laws that do discriminate against women. Now, this is a fact. It's not a matter of my opinion. The question of the family, this is a matter of fact, will enhance the status of women and will, if anything, make more stable and a more sharing relationship of whatever families we choose to have, because it will provide more options for men. Not only can women share more in the economic support, they can share. This is not to say, as Mrs. Schlafly and others have said, that they will be required to give 50% of the support in the family. That is absolutely false. What it does say is that women will have more opportunity as they choose, and these will be private decisions in the family, to share in the support, the economic support of the home, and men will have more opportunity to share with the home care and with the care of the children. Now, the there is no doubt that this has at least the potential, and where it's been exercised, the reality of bringing families closer together. So it will enhance immeasurably the status of women under the law and otherwise, and also, I think, will bring families closer together.
Mrs. Schlafly?
Well, I'm glad Ms. Heide brought out that she wants the wife to share in the financial burden of the family, and that is a great departure from the present law, which requires the husband to do it. Now, I'm also out that one of the things she wants is for the wife to establish a separate domicile. This is a great
No,
way
I
to
did
keep
not
the
say that.
family
Don't
together.
say something I did not say. I did not say
What
that.
did you say about the
I
domicile?
said, now you listen closely. I said,
Keep talking.
that she does not have the right to establish a separate domicile. I did not say that I want anybody to do it. We are talking about choice.
All right.
So I will not be misquoted.
All right. She wants the wife to have the right to have a separate domicile. Now, in the matter of credit, the Equal Rights Amendment will take away from the non-working wife her ability to get credit. Companies extend credit on a basis of ability to pay and the fact that you got a job. A non-working wife can get credit because her husband has a job and the store knows that he can collect against the husband. After ERA goes in, the non-working wife can't get credit anymore. Now, there are many states in which the wife's right in her husband's property is greatly superior to that of the husband. ERA will wipe out the wife's right in her husband's property and her right of inheritance and her right to be taken care of as a widow out of her husband's estate when the Equal Rights Amendment goes in, because no longer can you have any of these preferential laws that benefit the women so much.
We have about... Is that it?
No.
I'm terribly sorry.
Well, she has said things that are not true, and I think that
we'll be
should
back
known.
right after this.
Okay.
Right after this message from your local station. Ladies, we have 2 minutes for each of you. We're going to have to keep it to exactly 2 minutes, if you don't mind. So, Ms. Heide, I think Mrs. Schlafly finished, so why don't you take over? This is to summarize what we...
Let me mention a few of the other ways in which women are discriminated against by law, knowing, people should know that I am not detailing all of them. Women can now and have been and are given longer prison sentences for the same offense as men are given. Now, this is happening under the law. I mentioned the business contracts. I don't know if I mentioned the fact that some women cannot own the clothes on their back. It depends on their husband.
Yes, you did.
I find it very difficult to believe that any informed person in this country can really make the statement that Phyllis Schlafly made, that women are not discriminated against, with all the information that's available. They are discriminated against in the law and in the practices. It's normal. It's still considered normal. What we are talking about in this is it appropriate for one sex, based on the sex, to be excluded from the basic legal document of the land, denied the right of choice under the law? Is it appropriate for us to be, you see, any class of people excluded from a constitution is by nature of that exclusion a second-class citizen. And that's what the truth is today. So what we are saying is, let us leave it to individuals to make choices about how they will live their life, about whatever decisions they will make privately, but let's not have in a land that pretends to be a democracy the reality that the law itself will exclude women from certain occupations, and the right to earn a living for whatever reason, and it's generally based on need, must be available for people in this land.
Excuse me, Ms. Heide, that's it. Mrs. Schlafly?
Well, we oppose the Equal Rights Amendment because of the rights, benefits, and exemptions that women now possess that ERA will take away, such as the legal right of a wife to be supported by her husband, and the benefits that women have under Social Security and protective labor legislation, and the exemption that a draft-age girl has from the military. At these state legislative hearings around the country, the proponents of ERA have come in and said this is exactly what they want to do. They want to remove the sole financial burden on the husband in a marriage and make it fall equally on the wife. And they want women to be drafted equally with men and sent into combat. They want to wipe out the labor legislation and make the Social Security so that it has no preference for women. This is what they want and what they're saying. And I think this shows very clearly that they're going to take away from women some of the most important rights and benefits that we now have. This is why the 13 states have rejected the Equal Rights Amendment and why I think it will not go into the Constitution. There was one 90-year-old woman in Virginia who came in and testified that she'd been campaigning for women's rights since 1909 and was an original suffragette. She ended her statement by saying the proponents of the Equal Rights Amendment are fighting a battle that is long since won. They have the mentality of 50 years ago. Most American women do not think of themselves as second-class citizens. They know we have a wonderful position in our country, and to impose a legalistic equality on women would impose a realistic double burden because it's still the women who have the babies, and you can't change that. So for all of these reasons, and for the rights and benefits that women now have in our society, the greatest in the world, so far ahead of anything that's in second place, we urge the defeat of the Equal Rights Amendment.
Thank you, Mrs. Phyllis Schlafly. Thank you, Ms. Wilma Scott Heide. We'll be right back.